Good evening. This is the April 22nd, 2019 Zoning Subcommittee for the Revere City Council. What do we have, Madam Clerk? Please.
Roll call of the Zoning Subcommittee. Councilor Janino?
Here.
Here. Councilor Keefe?
Here.
Here. Councilor Novoselsky? Here. Councilor Rizzo is absent. And Chairman Zambuto. I'm sorry, ex officio member, Councilor Guanasso.
And the chairman is here.
The chairman's here. First item and only item on the agenda is Council Order 19-041, James George on behalf of Exonet Systems relative to the installation of a small cell wireless antenna on an existing National Grid utility pole near the intersection of 116 State Road and 4 Unity Ave.
Mr. George, would you like to come to the podium or you have someone else who would like to come up? Okay. State your name and address for the record, please.
Good afternoon, Mr. Chairman. Good afternoon, Mr. Chairman, members of the council, staff, and City of Revere residents. My name is Haran Rashis, and I'm the Director of External Relations at Exonet Systems, Inc. As you are aware, on January 22nd, 2019, Exonet applied for a permit to install a personal wireless service facility node on an existing National Grid wood utility distribution pole at the corner of 116 State Road and 4 Unity Avenue. The Federal Communications Commission has given municipalities such as Revere a presumptively reasonable period of time in which to act on such applications of 90 days. Today is the 90th day since Exonet's application was filed. Therefore, by law, the Revere City Council must reach a determination on our application tonight. At the city's April 8th zoning subcommittee meeting, Exonet's application was deferred to tonight. The entirety of the April 8th zoning subcommittee meeting revolved around concerns over the environmental effects of the radio frequency emissions of Exonet's equipment. In fact, the zoning subcommittee meeting minutes state that, quote, the special permit application will remain in committee until health-related scientific data is presented to the chairman. On behalf of Exonet, I have traveled the country speaking on state legislation regarding small wireless deployment. In almost every state, I have heard concerned citizens raise issues around the environmental effects of radio frequency emissions. While I do not agree with their assertions, I have also seen how passionate they are. I am not here tonight to address or argue with their concerns. Rather, I wish to speak to the legal issues around their concerns. Federal law is clear and unambiguous. Quote, no state or local government or instrumentality thereof may regulate the placement, construction, and modification of personal wireless service facilities on the basis of the environmental effects of radio frequency emissions to the extent that such facilities comply with the Commission's regulations concerning such emissions, end quote. As long as Exonet's equipment complies with the FCC's regulations concerning emissions, which it does, you cannot even consider the environmental or health effects of radio frequency emissions in reviewing Exonet's application. To do so would be an open, illegal act by members of this council. As I'm sure you will agree, filing litigation should always be a last resort. Litigation, by its nature, creates an adversary relationship. However, it is my responsibility in my job as Exonet that when a municipality fails to consider or improperly rejects an application, I have to take that issue to federal court, and we have a very limited time to do so under federal law. Back in law school, I was taught that when advocating for your client, you should keep 3 things in mind. 1, argue the law. If the law is not on your side, then 2, argue the facts. And then if the facts are not on your side, 3, just argue. Well, in this case, the law is not on the side of arguing about radio frequency emissions, either on a factual or argumentative basis. In a similar case, Loudoun County, Virginia, rejected a personal wireless system installation out of concerns for radio frequency emissions. The United States Court of Appeals for the Fourth Circuit ruled that the, quote, explicit statutory prohibition against regulating the placement, construction, and modification of wireless facilities on the basis of the environmental effects of radio frequency emissions is a limitation imposed by the Act on a council's authority. And the fact that a council relied on valid reasons to support its decision does not immunize its violation of a statutory limitation. The only way the City of Revere can now immunize itself from its violation of a statutory limitation is to approve Exonet's application, and I urge you to do so tonight. Thank you.
Thank you. I'm going to let some committee members speak, and then I'll share my views. We'll call on the council president first.
Mr. Chairman, to the learned attorney, did the FCC ever in their wisdom ask why they're asking for an opinion from a local authority if they can do everything they say is by right and you can just do it and place it any way you want?
If you want, I could
So
cite
what's
you-
the purpose of us even being here? Why is your application before us for approval or disapproval if we have no authority to not approve it?
You had zoning authority. You had aesthetics authority. You had a variety of various things that you could consider. If we were putting a new pole in, for example, to say that spot on the sidewalk, no one could get around on a wheelchair. Things like that are well within the purview of this
That would be
council.
difficult when it's up in the air, but even
If we were
so.
putting a new pole in to put it on,
So, okay, so
There are
our
many-
authority is limited to the few basics that you have suggested,
Correct.
and we are not to be concerned with health.
correct.
It would be foolhardy upon us to not suggest to our community that these might be harmful to your health. That's part of our role in protecting the environment to which our residents live. And so we're not arguing that tonight because you enlightened me. But you did say one thing, the aesthetics of it. I don't think they're very aesthetically valuable to our community. So on that basis, I have concern. So I could go and the City of Revere's representation towards our attorneys can go to the court and defend against that, saying that we think it's aesthetically does not enhance the neighborhood.
Unfortunately, the City of Revere has not passed, and you had until April 14th to do so under federal law, specific guidelines on the aesthetics. So this city has basically waived its right to do so at this point.
We're not afraid of litigation, I'll tell you that much, because on many occasions, we've litigated things that we thought was harmful to our community, and we were steadfast. And we're not looking to spend the taxpayers' money by any sense of imagination. But I know there is concern in the neighborhoods of our community of what's occurring. And when you were the first one that said it, in your travels throughout the country, sir, many people were opposed to this. They weren't opposed to it for not a valid reason. They were opposed to it because of many valid concerns that they have. And rightfully so. They have a right to do that. So you've admitted that
However-
there is objection throughout the community, throughout the country.
However, Councilman Patch, the
I'm
reason...
not Councilman Patch. I'm
sorry.
sitting in another seat.
Oh,
I'm better looking, so I sat here because
the rationale behind stopping cities from ruling on this is, number one, cities do not have, basically it was, I could quote you to the congressional report for the 1996 Act, that cities or municipalities do not have the resources to make the determination, especially on a antenna-by-antenna basis for the health effects. That, therefore, the Congress deferred that to the FCC. If your constituents have an issue with this, I would recommend they have basically 4 options. Hold on one second here. This is who they should be addressing. They shouldn't be addressing this council because this is not a local issue.
this is not a local issue?
No, this is a
Okay.
nationwide issue. If they have an issue with it, they should be addressing the FCC. The FCC takes comments on these. The FCC takes comments on any issue that is appropriate to them. If you're a John Oliver fan, about 2-3 years ago, he actually caused the FCC server to crash by asking for comments on a different FCC issue.
One further and last
But
comment.
the other 3 people that you should be addressing, or refer your constituents to is Senator Warren, Senator Markey, and I believe Representative Clark is your representative? That is who they should be sending their letters to, because this is a federal issue. And it's regulated on a national basis.
They're not
So we-
concerned about this.
What?
They're not concerned about this. They're keyed in on other issues. But I have one last point to make. When the presenter of your company came forward, Mr. George, and he stated all the facts and things, why didn't he state the section that you referred to, that these are our ways that we can go about if we thought so fit to deny the process? Why weren't we made aware of the reasons why we could deny?
You asked me that in a direct question.
That's a question.
My company is not going to get up here and say, oh, by the way, if you want to deny our permits, go through steps A, B, and C. However, I'm not going to stand here and lie to you.
It's
You
not
said-
an open, in fact, it's not a truthful presentation then, because you're supposed to enlighten us to go to some of these.
Actually, our application probably did say, this is how it meets this is how it meets this is how it meets that.
Thank you very much.
Council McKenna.
Thank you very much, Mr. Chairman. I just want to know, is there any fee that you guys get for putting these antennas up? I'm just curious. Any fees that you get? Like, if you, I know when we used to put them on buildings.
We're not putting them up out of the goodness of our heart, if that's what you're
No,
referring to.
I'm not saying, I'm not asking you that. I'm
we-
asking you if you get any fees for putting these antennas up.
Extenet builds the antennas,
Yep.
and then we lease the antenna back to the carrier. So in the case of the one that's being under application in Revere, we lease that back to T-Mobile.
So you
But
are getting a
T-Mobile does-
fee? You are getting a fee from the carrier?
Yes,
Okay, that's all
for
I
use of our
wanted.
equipment, yes.
Okay, that's what I want to know. Thank you.
Council Keith.
Thank you, Mr. Chairman. I have a few comments, and I gave you some information earlier that you can put into record, and I get that you may disagree with some of this, Mr. Chairman, but I wanted to give it to you on the record. I apologize, your name again?
Heron Rashis.
Mr. Rashis, I get it, you're the attorney and you're here to represent your company, and I respect that, and you've been honest so far to what I can feel. What I want to bring up is, obviously, this is going to be a long process where I think your company is going to be coming forth with more and more of these over the coming months.
Not just our company, but
Well,
you're going to
in
see...
other companies, I've
you're
already
going
heard.
to see all the carriers
Correct.
coming in.
So it seems like, as from a city, we're starting off on the wrong foot. And I got to be honest with you, and I think that your company maybe has good intentions, but clearly you're here to make some money and you're here to do a job. But what I don't like, and I have to say this, is we have a public hearing for a reason, and we want to get input from the public. And one of the first meetings, there was a public input commentary from a fireman, and that fireman happened to be in uniform. And he was very clear and mentioned that he was speaking on his opinion. What I don't like is the fact that after that person stated his opinion for his reasons, he's very passionate about these cell towers, very passionate, he spoke about it, is post-meeting, we're getting emails about how he showed up in his uniform, what he showed up in, what he was driving with, the brotherhood that he was with, and then on top of it, to me it seemed as if there was a personal attack from his Facebook page. So am I to believe that every time there's a city council meeting and we're inviting the public to come up and comment, that we're going to go ahead and retaliate on their personal social media pages? Is that how your company is going to act? Because I find that to be very unprofessional.
Extenet, I didn't, this is the first time hearing of that, and I can pretty much assure you, Extenet had nothing to do
Well,
with
I
it.
can tell you that from a city council, this noble body, and Councilor Zambudo, I highly doubt you would allow that, but if we're asking for public opinion, we may not like it either. We can take the hits, you can take the hits. We're the city council, that's part of our job. If you want to attack me, feel free to. You're coming up here for a proposal, you may get hit a few times as well. That's our job. But you leave the public out of it. If they have a comment, whether they're right or wrong, that's their right. And I'm just going to tell you that I will never tolerate that, and I would expect Councilor Zambudo not to tolerate that in his chambers either tonight. So I would hope that that's not the way you're going to operate, because we're going to go into this over the next few years where you want more of these, and you want us to work together.
First of all, as I said, Extenet had nothing to do with that. This is the first I'm hearing of it. That is
Well,
not the way we
I
operate.
would invite Mr. George up to explain that, because we received that email to the Madam Clerk, to Councilor Zambudo, and to other members of the council.
Jim George, Extenet AT&T. The methodology behind that, and I understand that you're upset about it. In my experience, if a city official says it's a personal opinion, and even speaking with firemen of other places and police in other places, as a matter of record, they must say they're a personal opinion or they're speaking on behalf of the city. The Facebook thing, personal opinion or speaking on behalf of the city. Now, these go in the direction they're going to go in. If the thing happens on Facebook, that's all going to be spinning around like it's going to spin around. Typically, I don't do that. Now, the lieutenant, I felt, shouldn't have been in uniform if he's speaking personally. That's what I felt. That's my position on that, Mr. Keefe. He shouldn't have been in uniform if he was not speaking on behalf of the fire department, if he was speaking personally. So that's somewhat hypocritical on him. So I even mentioned it to build my record. That's relevant in a federal arena. It's relevant. So I built the record.
Thank you for your clarity. Well, I just want to remind you, he made it very clear in both his social media page, which I totally think is off limits. You should see what they say about us on social media. We're not going to bring that up every day. We take those attacks. That's what happens. It's his freedom of speech. But what I will say, he made it very clear that it was his personal opinion, both in the council chambers and on his social media page. Very clear. Now, granted, he came in uniform, but many people come here after work in gas uniforms, and you name it. Teachers, whatever it may be, sometimes uniforms with their names on them. And yes, it can be a little bit cloudy, but I just want to let you know that we're not going to go that route if we're going to continue some sort of a relationship down the road. I would expect that. Now, I think that as a respectful company, you wouldn't take that from the first time you're coming or the second time you've come here before us for a permit, that you're going to go and attack any public comment. Because I can tell you that more people are going to come up. This is obviously going to grab more attention. So should they fear that if they come up and speak out of uniform, or if they speak on behalf of what they feel as neighbors and as residents of the city, they're going to be mentioned and attacked? Is that something that they should fear?
I have a problem with the word attack, okay?
Okay, so their personal opinions are going to be. This person came as a resident or as a representative of someone that represents the residents of the city. He's an employee of the city. He's an employee of the city of Revere. And he has a right to his opinion.
He does. If his statements are factually incorrect, I will correct them.
I have no problem with you correcting them in front of us, or if you had to send facts to the council and say that, just want to clarify that these facts are incorrect, I think that that's perfectly fine. But to go and to go after what he was wearing, how he arrived, the people he was sitting with, and then his social media page, I just think it was off limits. I think it's off limits. That's all I wanted. I wanted to make that very clear moving forward. Thank you, Councilor Zambo.
Well, one more thing.
Yes.
It's happened before in other areas. It has been litigated, and in the federal arena, I must clear the record up. So that is what I did, Mr. Keefe. Thank you very much for your time. Anybody else?
Councilor Janino, then Councilor Novoselsky.
Directly to me, or can I sit?
Thank you, Mr. Chairman. I just have a few thoughts on the whole issue, and if a good subcommittee, if any, is the place to put them on the table. The first thing I just want to address to my colleagues and to the people watching is social media has absolutely zero place in this chamber. Zero. In any issue. The business that we conduct in this chamber should be conducted in the chamber. It can be communicated to us through phone calls, through emails, through the city clerk's office. But social media is not a place to discuss business. You want to talk about what you had for dinner, you want to talk about your family vacations, wonderful to talk about on social media, but it's not a place to conduct business. So I have an issue with that, number one. But sticking to this issue, as a city council, we have a lot to look at, right? We look at the aesthetics, we look at public safety, we look at what's best for our community, if it's providing a service to our residents. Those are all things that we put into perspective. This is a tough conversation, and this is probably one of the first, I would say, in my experience in the council, of having almost an adversarial relationship with the company and feeling this much animosity working on a project that could benefit our residents, but at the same time, we're looking at the big picture, we're looking at the public safety and the public health, and if it's something that, you know, in my motion, I'm going as far as to say I don't want this on schools, I don't want it on fire stations, I don't want it on public buildings, it shouldn't be right outside of a resident's bedroom window or that vicinity. So what concerns me about this is not going to be the only proposal that comes before us. This is one of, I'm sure, many. And as a city, we need to look at this very, very closely. And I understand some of the attorney's information that he presented this evening on what our restrictions are federally and legally, but this is one of many, and we really need to take a look at this with our solicitor, and we need to get our ducks in a row to make sure that in the future, we're prepared and educated as a council to deal with these when they come before us, so we're not stuck with our backs against the wall, making decisions that we're not comfortable with. And I will say I'm not comfortable with this. I feel as if we don't have all the information that we need, and I feel as if that it's something that, again, this sets a precedent, and that concerns me. Thank you.
Thank you, Counselor. Counselor Novoselsky.
Thank you, Mr. Chairman. Sir, Counselor, could I ask you a couple questions, please? You mentioned April 24th.
April 14th.
Or 14th before, during your
Yes. April
oration
14th,
before, you mentioned April 14th.
Specific guidelines that we could have.
What did you mean by that?
I'd have to go back to the FCC order. And this, basically, the City of Revere does not have any specific cell phone, or not cell phone, but specific small wireless ordinance. If, you know, for example, and these are still things that you could do, what Member Ganino said, I hope I'm pronouncing her name right? Janino. She doesn't want it on schools. She doesn't want, those still can be passed by this council. But in terms of pure aesthetics, and by that I mean there are cities that say, you know, to quote Henry Ford, you can get a Model T Ford in any color you want as long as it's black. There are cities that say, paint it black, paint it brown, you know, things like that. Those deadlines, I believe, you had to do within so many days of the act, though I'd have to double check the FCC report. I have.
So then is it federal law or is just recommendations that we can't do that, or under what guidelines is that?
The outline for guidelines are in the Federal Communications Commission's third report and order and declaratory ruling of August 26th. No, I'm sorry, September 26th.
Okay.
Effective January 14th.
Okay, so basically, we can't deny it, but we can control it.
Yes, you can.
Okay, so, and that's what we've started. Our process has already started for that. Because we
Now-
have a public hearing tonight, sir, that was started before the 14th. So if once we pass it, there is a possibility that whatever we put in that ordinance could relate to everything that you're
Going
saying we
forward.
can't. Excuse me?
Going forward.
Well, as of the date we put in the start of the process. I'm not sure about that, but it's something I'd have to look at, because right now, with the telecommunications, if I'm correct, any applications cannot be started now until we finalize that ordinance.
That is incorrect.
Yeah, so,
Applications, you cannot put any moratoria on applications pursuant to the August FCC law. That would be any moratoria saying you can't start a new application. And even so, it works out that we've had municipalities tell us we're doing that, and the FCC order says proffered. So if we literally walk up to the clerk's office, drop that on the desk, and the clerk says, we're not accepting that, it's just like serving a subpoena. And I've done that as well, where you literally drop it at someone's feet, touched your foot, tough luck, you accepted it. I mean, that's the way it works. Now, that being said, I've looked at the plans for this pole, and there is absolutely zero within the range of guidelines that the FCC gives municipalities for this particular node. This node is on an existing pole. So there's nothing saying that the pole itself is not in the right spot because the pole's already there. I don't know how long it's been there. It's there. We work with NGrid to make sure that pole can physically support our equipment, is the right height for our equipment, the other pole owners. In addition, any rules, if you can't discriminate among different types of communication providers. Well, there already is cable on that pole. There already is landline telecommunications on that pole. So therefore, that pole already
There's
has,
no other tower in the pole, a cell tower.
that is considered under federal law a type. In other words, you can't discriminate between different types of service. So as long as there's communication services on that pole, ours is just a different type of service. I get all the time, I sit down with various city councils on aesthetics, and they talk about, oh, we don't like the way these look. Yet you go out there and you start looking around their own city at some of the things the electric company, the telephone company, the cable company have put on those poles. Our towers, I mean not towers, our nodes, there's a very big legal distinction between towers and nodes. Our nodes are roughly the same size as those rusty electric transformers that are all over the place. And quite honestly, ours don't rust because they're made of aluminum because of the type of material to allow the.
Could you provide us with that FCC information, where we can find it?
Sure.
Please.
I can give you the exact site if you want to write it down and look it up.
And while you're looking at, I don't know if Mr. George is aware of the site plan review recommendations that were put out. Mr. George? March 26th.
Yes.
Now, do you have an issue with those?
The site plan review letter of recommendation for denial, sorry. Please clarify what you're saying, sir.
On March 26th, the Site Plan Review Committee issued 3 recommendations to ensure structural integrity of the antenna, that the owner shall conduct periodic inspections at least once every year by a qualified independent engineer, with the results of these inspections being provided to the building inspector on an annual basis. That's number 1. Number 2, the owner of the telecommunication facility shall provide documentation showing that the telecommunication facility is in compliance with all applicable federal and state requirements. Evidence of compliance must be submitted every 12 months to the Department of Inspectional Services, City of Revere. And number 3, the telecommunication facility attached to an existing pole shall be equipped with an appropriate anti-climbing device to prevent unauthorized access.
These were the recommendations of the site plan review letter?
Yes, sir.
For this particular site?
Well, this one is for Unity Ave, so I'm guessing that it was
Okay.
for both.
I don't think we have a problem with that, no.
We read that all the time. Those are standard.
Okay.
As for the FCC order, and you can either write this down or rely on the video, the name of the case is in the matter of accelerating wireless broadband deployment by removing barriers to infrastructure investment, accelerating wireline broadband development by removing barriers to infrastructure investment, case numbers WT 17-29, WC 17-84, FCC 18-33, issued September 26th, 2018. If you do a Google search on FCC order, Federal Communications Commission, FCC 18-133, and make sure you find the final order because there are a ton of drafts up on Google as well, you should be able to find the order on the FCC website pretty easily.
Now, that's an order. Now, under what rule did they order that?
That was a declaratory ruling.
And what sections of
In addition-
their rules?
Only parts of it went into the sections of the rules. FCC's declaratory rulings under federal law are to be considered highly persuasive by courts. So in other words, if a municipality were to try to do something in opposition, or not opposition, but in opposite to this, then a court must give due deference to the FCC order. And the municipality must prove why that FCC order could not be followed or should not be followed. And in fact, there is a very large lawsuit against this brought by several municipalities around the country. The 10th Circuit denied a stay of this and allowed it to go into effect. So an FCC's orders are considered rule of the land. They also have the accompanying Code of Federal Regulations, which, in other words, the FCC orders are the persuasive interpretation of federal law. Then there's additionally, and the timeline for approvals and stuff like that went into the CFR. But the actual stuff about aesthetics, about what you can charge, those are in the FCC order because they differ everywhere. In other words, the FCC could not say to every city in the country, just as an example, you are limited to 45 feet, or the size of a small wireless system. The FCC, quite honestly, in my opinion, went way overboard on the size of a small wireless system, saying 28 cubic feet and exact dimensions and stuff. But basically, the FCC set a maximum for it. In addition, the FCC said stuff like the fees that a municipality can charge cannot exceed a certain level without persuasive argument. So the FCC order is the rule of the land, but it's not actually in the Code of Federal Regulations. And that goes back to the way the FCC is structured under federal law.
Thank you.
Council Patch, quickly.
I'll be real quick, Mr. Chairman. I wasn't here for the beginning of the meeting because I'm not on the committee, but
Don't worry, someone's sitting in your seat speaking for you.
I've been following it through correspondence. I got one quick question here. This vote is only for Ward 1 councilor for Unity Ave, for 2 polls in Unity Ave, correct? One. Okay, in your ward, though? Yes. Okay, well, a vote for this is not a vote for other polls that come in.
It is only one small cell node.
I didn't address you,
Not
sir.
Point of order, point of order.
State your point.
Thank you. I thought one was on Unity Ave and one was on State Road. I think there was 2. No, that's what I heard the last meeting. One was across the street, one was right on top of Dunkin' Donuts, and the other one was where the Colombian restaurant on Unity Ave was.
The issue here, we are proposing one small cell pole, which is at the corner of 116 State Road and 4 Unity Ave. From a prospect of what address to use, there was confusion. It's basically kind of sort of in front of both places. It is the same pole. One pole, one address. But from the standpoint of being in the right-of-way without a physical address, the assessors and us said, let's do it this way. So I apologize for the 2 addresses here, but it's one pole.
Unfortunately, it's more confusing, but it is on the application with the specific latitude, longitude location, but to the average person in the public, if you were to say, oh, we're putting something in at, I don't even know the numbers here, 47 ... 72 ... it doesn't mean anything.
Thank you. Councilor Rizzo, you have something to add?
Yeah, so I just have more of a comment than a question. I normally, historically, putting up an additional tower, is just part of doing business. And, in this day and age, you'd be hard-pressed to find anybody without a cell phone. Everyone's got a cell phone. They need signal. Everyone gets frustrated when you don't have signal. We all know that. But I have to say, I was a little bit alarmed when I saw Lieutenant O'Hara's letter. As these signals become stronger over time, I don't know if it's 3G, 4G, 5G, and however many Gs will ultimately be 10, 15, 20 years from now, if there are actual health ramifications that come from this, then I think we do have cause as a municipal board, as a city council, to protect the public health of our residents. My wife used to work for Mass Electric, now National Grid, and she says, I would never live near those high power lines. That's documented, she said. People that live close to high voltage power lines are more at risk for health concerns. So, you know, these electromagnetic fields or whatever are being emitted from all of these electronic devices that we're dealing with today, to me, are an issue. And so when people that don't live in the city, and no disrespect to you, you have to go to other municipalities and talk about these same things, but you come in here telling us that, you know, hey, look, this is what the FCC says, you guys got to do it. I mean, part of me is like, why do you need us then? Why, if this is all laid out with the FCC, what do you need to vote for? Just go do it. You know, I mean, to be lectured to and talked to as if, like, our vote really is irrelevant because at the end of the day, you're going to get it in court anyway, it really doesn't matter. You know, but to me, as just one city councilor, that not only has to deal with the additional electronics that the community has to absorb, but we've got Resco down the street, you know, and not to get into a debate over that because people have differing opinions, and I respect all sides, but in my opinion, you know, you've got toxins that are leaking into our environment, whether it's through the land or through the air, that people have genuine concerns about. And I'm not going to be one that's going to diminish their concerns, whether there's factual basis for it or not. It's things we can see. The same with these electronic devices that you're putting on our poles across the city. And so that letter, I have to say, by Lieutenant O'Hara, was a little troubling for me. And to be honest with you, because of things that I've learned and read over time, is troubling. So, I mean, I don't know the practicality of us voting it down, if it only delays it, but you're going to get it in court anyway. Maybe that's one thing, but I will say, I think that more studies, more data, I think just has to be physically given to city councils if you're expecting across the state or across the country for people to keep voting for additional more and more devices that are going to be put in our community to make sure that the health and welfare of our citizens are protected. That's all I really have, Mr. Chairman. I appreciate the opportunity.
Thank you, Council. I appreciate it. It appears to me that there's not enough information for my colleagues to make an informed decision here. Now, I've gotten some documentation, but I have to say the only scientific documentation I got was from the proponent. I've gotten a lot of opinions, similar to the opinions I've gotten during Wheelabrator. High emotions, people are afraid, and they should be. But the people that we have to trust have told us they're safe. I'm not going to go down that road tonight. What I am going to do is keep this in committee. I can keep it in committee. I can do what I want. I want to keep it in committee, and that's what I'm going to do. And I know this gentleman's going to tell me that it's going to... I'm the zoning chairman. I'm keeping this in committee, and that's where that stands. And I would appreciate if anybody can come up with some scientific data, actual, factual data, not opinions. That's not factual data. All right, we're not going to debate it because I disagree. And so that's it.
Mr. Chairman,
that ends the zoning
Mr. Chairman, if I
subcommittee.
may, one question through you to the clerk.
Go right ahead.
What are our potential actions right now?
I would have to defer to our city solicitor regarding what happens after the shot clock runs out. I'm not sure.
we were on our 90th day?
That's correct.
Thank you.
That ends the zoning subcommittee for April 22nd, 2019.